2 has reported extensively on the backlog of criminal cases in St. Louis.
Justice delayed for victims is also justice delayed for the accused. In today's Legal Lens, Fox 2's Jeff Bernthal asked Brown and Krupin's Andrea McNary for the legal meaning behind the right to a speedy trial.
Andrea, we hear this phrase, right to a speedy trial. I guess, how long is considered too long for a defendant to have to wait for their day in court?
Well, the answer depends on where you're charged. If you're charged under federal law, a trial must commence within 70 days of the indictment or when the defendant first appears in court. In Missouri, what the law says is if a defendant requests a speedy trial, the court date must be set as soon as reasonably possible. There are exceptions. That's kind of a nebulous definition, as soon as possible. But we do know from some of the case law that it is presumed 9 months is too long.
Before something got to the point where a judge might dismiss a case, what are some of the factors that they would consider?
Both a prosecutor in deciding whether to pursue a case and a judge looking at a case, they could consider lost evidence, lack of evidence, if it's being delayed because, the reason being they're still trying to gather evidence and quite a long time has passed. If there's substantive procedural issues anyway, and the judge can even look at lack of resources. If the judge is looking at continuances for criminal trials and he knows there's no reasonable way this type of crime would be prosecuted and take precedence over other crimes, a judge could dismiss for lack of prosecution.
And lastly, if you can help us understand when double jeopardy would apply, a situation where someone could not be then, charged again with that same crime.
So double jeopardy actually has to do with whether somebody is found or a case is dismissed on the merits of a case, meaning whether somebody's guilty or innocent. So that's when double jeopardy would apply. Usually if it's a misdemeanor and it's dismissed for failure to prosecute the case, double jeopardy would apply. Or if there was a violation of the right to speedy trial. If it's a felony, usually the prosecution gets a second bite of the apple. But if it's again dismissed for failure to prosecute or failure to provide a speedy trial a second time, then double jeopardy usually would apply even for felonies.
It's a topic a lot of people have been talking about lately. Andrea McNary with Brown and Krupin. As always, we appreciate your time. Thank you.
You are so welcome.
Jeff Bernthal, Fox 2 News.
And remember, you can catch the Legal Lens on Fox 2 every Wednesday at 6 p.m.